Gotham investigations. We're going to have a defense attorney that represented the mother of a girl who claimed raped by her father. Imagine you are now the defendant with claims of rape to your daughter, and now you're being charged for threats of violence. This incredible story will only be told on Gotham Investigations, and your questions will be answered. Gotham Investigations, we are here with one of the top-notch defense attorneys in the industry, again, Dominique Russo. And Dominique is super excited because she just had a recent acquittal on a case that quite some unique circumstances. You want to tell us about this, Dominique?
Sure. First of all, thank you for having me, Jeff. I'm excited to be here. So this case you're referring to was a criminal case out of Broward County. I was representing the mother of a teenage daughter who, unfortunately, there were allegations that the girl's own father had been sexually assaulting her over the course of several years.
So along with these allegations, was there any proof? Was there any semen samples taken? Was it proven that this did happen?
Right. So the allegations were very, very detailed. There was an entire police investigation into these allegations. And the police investigation ultimately terminated when the police took a photograph of the father's genitals, and then they asked the daughter to draw a picture of the genitals, and they compared a young girl's drawing of her father with the actual photo. And based on that comparison of a child's drawing to the photo, the police said that they didn't match because there was more hair than it had in real life and things like that. And they ended up closing the investigation because of that.
Now, how old was this child?
It was over the course of several years. It started around the time of 7 or 8 years old and went until she was about 12.
Okay, and there was no recent test done with the...
There was no DNA, nothing solidifying it, so ultimately it was the girl's word against the father's word. So the father was never actually charged. So yes, these were mere allegations at this point. But the mother eventually came to learn of these allegations.
Are we talking about like full sexual content or exposure or touching?
Full sexual penetration was the allegation. And frankly, my standpoint in the trial was it doesn't really matter if it happened or not. We did put forth the case that we do believe that it happened, but it didn't really make a difference whether it happened or not. What mattered is...
So why were you representing the mother in this case? Right.
So the mother came to learn of the allegations, and as any mother would be, she was very upset. In her upset, she sent off a slew of angry, frustrated, venting, ranting, and raving text messages and emails. Within those, there were some choice words. You know, there was a lot of swearing, a lot of cursing, as anybody would if they just found out something like that, as well as empty threats saying, I'm going to kill you for doing this. There was no follow-up, there was no plan, there was no buying of a weapon, there was nothing to support the allegation that she would truly go and act out these written threats to kill. So that's what she was ultimately charged with, written threats to kill or do bodily harm. She was charged with 2 counts of that, so she was facing about 20 months in prison at minimum. She could have gotten much more prison time than that. So they actually
arrested her.
So they arrested the mother. Instead of the father, they arrested the mother for making these threats and charged her with 2 counts, which was a felony. She was facing a lot of prison time. I ended up very aggressively trying to resolve this case by bringing to light all of these issues with the prosecution. I even went as far as elevating this to the supervisor, to the chief of this unit, and I was shot down time and time again by the prosecution, saying, it doesn't matter, she can't go making threats like this. Doesn't matter if the dad had done these things or not. They weren't willing to have it. So we set the case for trial, and on the morning of trial, the prosecution made an offer to resolve the case in a withhold, to a withhold of adjudication, which is not a felony conviction, and they offered probation. But at that point, I told the prosecutor, look, I had been trying to resolve this case with you for so long, and you were not giving me the time of day. I said, we're here. Obviously, I consulted with my client on it, and she wanted to fight. And I said, no, I'm not scared of your threat. We're going to trial. And we went to trial, and jurors were crying when they heard about the allegations in this case. And ultimately, we got a not guilty in an hour.
Well, you're making me cry now. So was there any history of violence that this your client had?
My client had no history. The father, on the other hand, had an extensive history of arrests, injunctions against him, things of that nature.
So obviously they're separated now. The child
yes.
is taken away. Is there any protective custody that she has with this child now, or is the child of age now? Like, does the father still have rights to see the child?
Technically, yes, which was another thing that we were worried about, that if the mother went to prison because of this, then technically the dad still has custody. And that would be just horrible to put the girl back into his custody, especially knowing that there were these allegations against him.
So a lot of defense attorneys, they graduate from law school and they just open up their defense thing. But you have a history of being an investigator yourself. How did you start in the investigation business, and where did you work?
Yeah, so it was actually before law school. This was the way I figured out that I wanted to become a criminal defense attorney. First, I went to grad school for justice and public policy. Quickly realized that I didn't want to be sitting behind a desk all day doing research. So I ended up getting a job at the Washington, D.C. Public Defender's Office, where I was an investigator there.
Was there any training involved in that?
Yeah, there was extensive training. It's one of the best, if not the best, training program for criminal defense investigators in the country.
So take us through some of the curriculum.
Sure. So, well, one of the biggest things in DC and how it compares to Florida is that in Florida, as you might know, criminal defense attorneys have the opportunity to do depositions of witnesses and victims in a prosecution's case. So a deposition meaning that you get to sit down with a court reporter and the defense attorney gets to ask a bunch of questions of the witnesses before you go to trial. So in Florida, way before trial, you know everything this witness is going to say, everything the victim's going to say. In Washington, D.C., and I don't know if the rules have changed since I lived there, but back when I was doing my investigations there, the defense was not entitled to depositions. So in order to figure out what the witnesses and the victim were going to say in trial, it was incumbent on the investigator to go out there and convince these witnesses to talk to them. So I was kind of the counterpart to the police detectives. I was going to the same witnesses, knocking on the same doors, but this time I had to knock on victims' doors and say, you know, hey, I'm helping to represent the guy who allegedly robbed you, whatever it might be. Please talk to me. And I had to get my foot in the door and convince them why they should talk to me when it really was not in their best interest to do so whatsoever. So the training in DC was really heavy on learning how to get your foot in the door and how to take written statements from these witnesses.
So when you take a written statement, is there any criteria specifically that you're trying to do to fulfill a
Yeah,
need,
so
content?
we would take the written statements in the first person. So I would be writing the statement by hand as if I were you. So I would do a whole interview with you first before I ever wrote anything down. And then once I started writing, I would say, all right, let's start from the beginning. And I would say, as if I were you. On April 1st, 2024, I was driving down the street. I was approached by somebody, whatever it might be, from your perspective in the first person. But what was interesting is that because I was writing the statement instead of handing it over to the witness, now I'm in control. I'm in control of making sure I touch on all the legal elements that I need to get into that statement, but also in control of kind of how I craft the narrative. And of course, you're reading over it at the end and you're signing off on everything, and nothing I put is untrue, but
you're making sure that it has all the content.
Making sure it has
necessary for court.
everything that is going to be helpful for us as the defense at the end.
Okay, so that was one of the steps you've taken. And explain to the audience when you don't have money and you get a defense attorney, and how in the legal system, even here in Florida, you can have a regular attorney if you don't have money, if there's a conflict between defendants where they can't get a public defender because there's a conflict. Now they can seek legal advice from a private attorney, and it gets paid for from the state, as well as the private investigator like myself that's on a lot of defense teams.
Right. So, like you said, if you don't have money to afford an attorney, you can get assigned to the public defender's office. If the public defender's office has a conflict, because, for example, let's say the public defender's office represents the victim in the case, that the victim happens to be a defendant in a different case, then the public defender's office is going to have to conflict off of that case. If you still don't have money for a private attorney, you might get sent over to the wheel, which is private criminal defense attorneys who take court-appointed cases. But if you can afford an attorney, then you go and you have to go and look for a private criminal defense attorney, which is what I'm doing now. But I did start at the public defender's office.
Okay, so you get a case, let's just put a murder case, for example. You're the investigator for a defense team. Obviously, you have an outline that you're going to go through, and you're going to read the discovery. What does your outline consist of?
As an investigator?
As an investigator.
So, I mean, there's so many parts to the investigation, as I'm sure you know, right? There's
Do you
trying
start with
to
a
obtain.
timeline? Do you put a timeline together? How do you
Well,
start the
oftentimes
investigation?
your defense theory is evolving as you investigate, right? Sometimes it's very cut and dry, right? If it's a murder case where it's a clear-cut self-defense, then what are we going to look for? We're going to look for surveillance footage that might have caught it that the police missed. We're going to go canvassing, knocking door to door, see if there's any witnesses who might have seen something transpire that could be helpful for us. Maybe they saw the victim lunging at the defendant first. That's, when we know what our theory is going to be from the beginning going into it just by reading the arrest affidavit. But sometimes, our theory is evolving. We might not have a super clear-cut defense theory right from the beginning, so a lot of it is going to be kind of working on the fly as you talk to witnesses and hear what they say. And that was another reason why being an investigator, at least in DC, I think really prepared me for being an attorney because I had my boots on the ground and such a critical part in forming the defense's case. I had to be thinking about those elements of the crime and what elements we need to overcome, which is huge when you are a criminal defense attorney, is always keeping the elements in mind at the end of the day. So for example, in that case that I was just talking to you about that I went to trial on, the key element that I ended up winning on was, well, there were multiple elements, but first, it was a written threat was made, right? Yes, there was a written threat. It was sent to somebody. Yes, it was sent to somebody. But the element that I won on was that it needs to be a true threat. So that was the whole case that we've put forward to the jury was this a true threat, or was this just venting, ranting, and raving? And that was what that whole case was revolved around.
So a lot of times these judges stop from bringing in evidence and different things. That's a huge obstacle.
Oh, yes.
That I've faced a bunch of times, especially like in battery on police officer cases where I'm an expert use of force witness and stuff like that. How successful have you been in bringing things into trial where you create an ulterior motive of a suspect that did the murder or the crime?
So, well, ulterior motive of a suspect, I'm not sure I've had many cases where we've ended up having to actually put on evidence of an alternative suspect. Obviously, there's many times when you raise doubt, saying that it could have been somebody else, but only a limited number of times when when the defense is affirmatively putting on evidence of somebody else. But it's actually interesting you mentioned about judges not letting evidence in, because that case I went to trial on, I experienced that immensely. One of the things that I really wanted to bring out in the trial as defense evidence was that the father of this girl, he didn't report these alleged threats for over a year, right? And yet now at trial he's claiming that he's truly in fear. Until the day that he reported it is the day that they went to a child support hearing, and the day that his child support went up over $800. That's the day that he chose to go to the police and chose to report this threat that he was so afraid of. But the judge did not let that evidence in.
Yeah, it's crazy, some of these judges, especially in some of these small towns. I was an expert witness in one of the counties out west there, Beach County. I don't want to mention which one, but the officer was involved in a aggravated battery with my person hired me as an expert witness on the defense for use of force, that the officer was too aggressive. Obviously, the body cam footage was all lost and everything else. They entered this individual's the garage after he said several times, "Do you have a warrant?" The wife is the one that called the police from a secondary location. Hours later, they showed up. But ironically, at the trial, I had his internal affairs folder from this individual's Bratton Beach that he came from, the apartment, and in there he had an IA complaint where he was using phonetic spelling with domestic violence at a park, and he was using N for, you know what? L for lynching, and this is how he was saying the name, doing a background check on
The
video.
cop. The cop was-
Yeah.
wow.
The cop was doing it, like N for this, L for lynching, and literally everything. And that's what he was fired for from that department. Now he comes to another department, and the judge would not allow that in, supposedly by the defense attorney said that. So I go up on the stand, I'm ready to say my experience, 30 years of law enforcement, and how, you know, they didn't even ask the wife for an ID. It could have been a disgruntled neighbor that said they had a dispute. They tasered this guy several times. So I go up there, they ask for my background information, I give it. I hear a sidebar and a judge saying these are these small towns where I guess they don't want to get sued. The defense is kind of in with the, you know, the town, the city. They have to live there with the police. I hear the judge tell him, "I don't like where this is going." The defense attorney comes up and says, "No further questions." I'm like, "No further questions?" I mean, this guy paid thousands of dollars for me to be an expert witness,
Yeah,
and
right.
that was it.
Right.
And he got found guilty. He was a church-going guy. He had diabetes and everything. Now he's sick in prison. He got a couple of years from that. And I am going to have a couple of his family members on soon for a podcast. But why do these judges do that? I mean,
A lot of times, you know, either witnesses in the middle of trial or the jury or spectators watching a trial will see things like that happen,
but
right?
obviously it opens up for another trial, because I'm sure that
It could. It was probably something that the judge had already ruled on before trial during what's called motions in limine, where motions in limine, both sides get the opportunity to argue to the judge that certain pieces of evidence shouldn't come out during the trial. So oftentimes when you hear the judge just abruptly say, you know, we're not going that far, we're not getting into that, or there's kind of an unspoken understanding between the judge and the attorneys in the room, oftentimes they're all thinking back to that motion in limine where the judge already decided that that's not allowed to come out and you can't go that far. But then everybody else watching has no idea why it was that it stopped there.
So I always have this theory, and I'm sure you have the same one, it's like you're innocent until proven guilty, but that's not the case in the criminal system. You're guilty until your innocence is proven, because some of these people are in jail 4 years to 7 years without even going to trial yet, and they don't know if they're guilty or not. It's
very true.
It's crazy.
So much time spent in jail. I represented a kid who was about 18. when he was charged with second-degree murder of his stepfather. And his stepfather had been extremely abusive to his mother over the course of many, many years. And this kid, one day, there was an altercation, and the kid stabbed the stepfather in the leg one time, and it just so happened to hit an area that caused him to bleed out. And this kid sat in jail for over 3 years. Wow. Over 3 years before we finally resolved the case.
That's crazy.
That's a sentence in and of itself. And he was innocent at the time, presumed innocent, and yet you're sitting in jail for that long.
Now, I've seen plenty of like homicide cases and different things like that. So I'm an individual, I'm a citizen. Not every defense attorney is proud to do what you do, and some are just in it for the money, scamming. Do you recommend me, if I did a crime or convicted of a crime, going to trial, that I go up for every sidebar that the judge has?
As a defendant?
As a defendant, yes.
I don't know if the defendant can.
Well,
I've never seen it happen.
I was in a murder trial where every sidebar...
The defendant would go up?
It was a death penalty case, yeah. The defendant would go up on every sidebar.
I've actually never seen it happen, but I presume the defendant has the right to be aware of what's going on. Yeah.
So would you recommend that? Because obviously sometimes things are being said.
Oftentimes you need to appease your client to make them feel comfortable with the process. And if that's what they need to feel comfortable with, this trial and knowing what's going on in the trial, then okay. But I do think it opens the door a little bit to the defendant starting to argue with their attorney about the law, right? Because what's happening at these sidebars is you're discussing the law and whether the law allows certain evidence to come in or not. And to bring a lay person into those conversations, I think a lot of things that are said are going to probably go above their head and just lead to a little bit more confusion on the part of the defendant.
So one thing that I've always wanted to ask a defense attorney, and I've never had the chance until now because it's never come to mind before.
Oh boy.
And I've been to many trials and sat through many murder trials and everything else. What is it with the stupidity that you have the client sit there like if he's writing things down throughout the whole trial? That's the stupidest thing I've ever seen, because obviously he doesn't just become a genius.
Look, they can't say anything, right?
Down.
Imagine you're sitting there on trial hearing lies or inconsistencies.
Yeah, but I think it's so corny. What is I would like to get that paper and say, what have you written?
But how hard would it be, right? To your attorney instructs you beforehand, don't make faces, don't sigh, don't roll your eyes. You have to sit there stoic listening to these things, and especially if they aren't true, I think it's an outlet more than anything. I think, yes, the attorney takes a look at it and sees if there's anything valuable there, but it more than anything, I think it's an outlet for the defendant to be able to express their frustration and not blurt it out, as I'm sure many of them want to.
Kind of like focusing on a paper clip just to keep you concentrating and not your surroundings to get distracted, type of thing.
Yeah.
Well, if you want defense from a -- defense attorney in the state of Florida, which you also do some personal injury as well.
Yes.
You do some family law as well.
Today I was in court for a dependency hearing, which is where the state is essentially intervening when there's allegations of child abuse or neglect. So I do a little bit of that. I do some civil injunctions, so restraining orders on either side. And yes, as you mentioned, personal injury, so car accidents, slip and falls.
So I just murdered somebody and I need defense. How do we contact Dominique Russo?
You can text me 24/7 or call me at 305-209-5301.
Are you a fan of our show? Do you like our show? Then subscribe to Gotham Investigations, comment, and hit the like button, or you might be the next one we investigate.